Welcome to another episode on the La Rapport. This is episode 4 of 2026, and today we are going to discuss the concept and legal framework of legitimate expectation. Recently, very recently, a potential client reached out to me concerning a matter in this area of the law, but I declined to act for that client because I no longer do serious litigation work. Most of my practice, maybe 95%, is now confined to my desk where I shuffle paper. Welcome back. Now, before I proceed any further, please note that nothing that I say in this episode is legal advice and should be construed as such. For legal advice, please contact a competent attorney of your choice. Now, what is legitimate expectations? Legitimate expectation is a public law doctrine that protects individuals or businesses when a government authority promise, representation, or established practice leads them to reasonably expect a certain benefit or treatment. It ensures administrative fairness, preventing the state from abruptly reversing course without justification. The doctrine of legitimate expectation is relatively new. It is a new concept that has been fashioned by the court for the review of administrative actions. This concept gained standing after it was introduced by Lord Denning in the case of Smith versus the Secretary of Home Affairs in 1969. In that case, Lord Denning recognized, albeit obiter, that is, by saying, by mentioning it in the course of the case, so it did not actually form part of the ratio decidendi or the crux of the ruling. But Lord Denning did recognize the right or the interest, what he called as legitimate expectation of an individual against an administrative action and the right to be heard. So, brief facts in that case of Smith and the Secretary for Home Affairs. Back in 1969, it was the general policy of the Home Office to allow aliens to enter the country for study. That was people who were not British citizens. The plaintiffs in this case were allowed to study at the Hubbard College of Scientology. In 1968, the Home Minister said, in answer to a written parliamentary question, that he considered Scientology harmful. The plaintiffs' request to extend their stay at the college, but the Home Office refused. They brought a case based on legitimate expectations against the Home Office. This claim was dismissed by the Court of Appeal. It was held that they had no right to stay in Britain and they were not entitled to a fair hearing, and that the Home Office had not breached the rules and fair procedure. So, in that case, Lord Denning stated, and I quote, "An administrative body may, in a proper case, be bound to give a person who is affected by their decision an opportunity of making representations. It all depends on whether he has some right or interest, or, I would add, some legitimate expectations, of which it would not be fair to deprive him without hearing what he has to say." End of quote. So, as coined by Lord Denning, legitimate expectation is an expectation of an ordinary man to have benefit or relief, which is a consequence of a promise or representation either expressed or implied, made by the administrative authority concerned or its prior established practice. Hence, a legitimate expectation is an expectation to be treated in a particular way by the administrative authority or to receive some benefit as a matter of public law, although no such enforceable right is conferred on that person under private law. This right or interest is enforced by the courts through the process of judicial review. Rather than judging the merits of a conclusion, judicial review assesses the legality and process behind the decision. So let's look at some of the entities that will be subject to judicial review. So the government and the executive, ministers, government departments, government agencies are all subject to judicial review. Local authorities like planning boards and local public services, etc., are subject to judicial review. Regulatory and public bodies, such as statutory and administrative bodies, are all subject to judicial review. And in certain cases, private entities could also be subjected to judicial review. Companies and entities such as universities that are contracted to carry out specific public functions. So the entity must be engaged in some public function to be subjected to judicial review. And yes, the police force and commissioners of police are legally subjected to judicial review because they act as public authorities exercising public functions. Their decisions, their policies, and their actions can be challenged in the Supreme Court of the Turks and Caicos Islands if it is believed to be unlawful. So, to be clear, the doctrine of legitimate expectation is not a specific legal right engraved in a particular statutory or rule book. The first time an attempt was made to establish the principle of the doctrine into law was in the case of the Council of Civil Unions and others against the Minister for the Civil Service in 1985. Remember, in 1969, Lord Denman only mentioned it in the case, but in 1985, there was a concerted effort in this case of Council of Civil Service Unions and others against the Minister for the Civil Service to actually embed or to give the doctrine some sort of legal footing. Now, it was held in that case that any decision by a public authority that affect the right of a person or alter any obligations to that person can be enforced, and the principle of legitimate expectation. So the person must be deprived of some benefit or advantage which he has been permitted by the authorizing body in the past, and which he could have legitimately expected to enjoy until a valid ground for withdrawal of the same was communicated to him or her, and he or she had been assured by the decision-making body that such a benefit or advantage would not be withdrawn until he or she is given an opportunity of contending reasons as to why they were withdrawn. However, in cases based solely on legitimate expectation, the plaintiffs or the person bringing an action must manage the expectations. Why do I say that? Well, legitimate expectation does not create an absolute right to a particular benefit or outcome. We'll look at the type of legitimate expectation. The doctrine requires a clear, unambiguous, and unqualified assurance. Once this benefit is established, the legal framework generally breaks down the doctrine into categories. For example, the type of legitimate expectation. So it could be a procedural expectation, and this will arise if the authority promise that a specific procedure, such as consultation, notice, or fair hearing, will be followed before a decision is made, or even if no explicit statute requires it. Once the promise was made and not followed through upon, an issue of legitimate expectations may arise. Then there is substantive expectation, and this may arise when an authority promises a specific outcome or the continuation of a concrete benefit. This is harder to enforce, as courts must weigh the individual reliance against the state needs to change policies for the public good. Now, what is the core legal test in a matter of legitimate expectations? When assessing legitimate expectations or any claim, the court typically evaluates three key questions. First, the court will ask itself, was the expectation reasonably raised? The representation made by the public official must be clear, lawful, and actually authorized. General vague political promises usually do not qualify. The court would ask itself, did the individual rely on the promise? While not always an absolute requirement, courts heavily favor claimants who rely upon the promise to their detriment. Example, expending money, changing residential plan, restructuring the business, etc. And the third question the court would ask itself is if there is an overriding interest. So even if an expectation is proven, an authority or department can depart from its promise if it has a compelling, rational public interest or statutory duty to do so. The burden rests on the authority or the public body to prove this justification. And finally, what are the remedies available in these matters or matter for judicial review based on legitimate expectation? Well, judicial remedies could be mandatory orders where the court could direct the public body to honor the original promise or procedure. Court could crush any orders made, cancelling the authority new decision, forcing them to properly consider the matter or the situation in a fair manner, or the court can grant a declaratory relief stating the rights of the aggrieved party to guide the authority next step.
Here is where I leave this episode for today. If you learn anything from this episode and you find it useful, please like, please share, please comment, please give it a thumbs up, and I will see you very shortly in episode number 5. Cheers.